validity of the Section 6A of the Citizenship Act. This was the crucial hearing that was in fact being given today, and the Justice Pardiwala has dissented. The order and the pleas challenging 6A are in fact have been dissented by Justice Pardiwala. CJI said that there are three judgments, and Justice Pardiwala in dissent as far as the 6A of Citizenship Act is concerned. The majority judgment has upheld the validity of the constitutional provision. We are tracking the big development that in fact we are breaking at this point of time. There is a verdict on the Citizenship Act, which is now deemed to have been validated by the Supreme Court. Supreme Court has upheld the Section 6A of the Citizenship Act of 1955, and in fact the details of there are right on your screen, viewers, where the Section 6 of the Citizenship Act is now validated. Justice Pardiwala has dissented over the validity of Section 6, but it's a landmark verdict by the top court, viewers. All right, viewers, this is in fact is one of the verdicts that were expected today, and definitely scripts a landmark judgment in the history of the justice system, where the Justice Pardiwala has dissented over the validity of Section 6, but the Supreme Court upholds the constitutional validity of Section 6A of the Citizenship Act. All right, viewers, now joining me on the broadcast is my colleague. As you can understand, this is the landmark judgment that we are breaking at NewsX at this point of time. The validity of Section 6, the Citizenship Act provision Section 6A has been validated by 4-1 majority verdict. Joining me on the broadcast is my colleague Nibir Deka. Nibir, very good morning to you. Now, in fact, this is a landmark judgment. In the share of 4-1, the Supreme Court has upheld the Section 6A of the Citizenship Act 1955. Indeed, a landmark and historic judgment. What are the latest details that you're tracking?
Yes, indeed, it is a landmark judgment by the Supreme Court of India. Supreme Court of India by 4-1 majority has upholded the Section 6A of the Citizenship Act 1955, which has recognized the Assam Accord. One of the justices had dissented. However, the CJI, along with the three others on the bench, two others on the bench have given in majority verdict. This is very significant for Assam because Assam had faced the issue of illegal infiltration and along with the other border states of the country. However, the cultural impact on the illegal infiltration was significantly higher, and as such, there was a 5-year Assam agitation in the 1970s, which led to the signing of the Assam Accord. And based on that, the Section 6A of the Citizenship Act was very crucial because it upheld the Assam Accord, and today the Supreme Court verdict is very crucial because it gives legitimacy to the Assam Accord, which was a result of years and years long agitation in the state. And this verdict will definitely put forward the issue of illegal infiltration and help save the cultural as well as linguistic diversity of the state. Back to you.
Well, definitely, Nibir. Also, for the benefit of our viewers, give us a insight of exactly the act which we are talking at this point of time, the Section 6A of the Citizenship Act of 1955, which recognized the Assam Accord. And now in the majority of 4-1, this in fact has been made as a landmark judgment. But to give us a sense of how crucial it is, what this means, give some idea about what this judgment exactly means and intends towards.
Background context to it, Section 6A of the Citizenship Act 1955 was introduced in 1985 following the signing of the Assam Accord, and it was the legislative enactment of the Assam Accord. As I told you, it was after years and years of agitation, some people got the Assam Accord, and it classified illegal immigrants of Indian origin who came into Assam from Bangladesh into three groups. So there were three different cutoffs, a date for the people coming from Bangladesh to Assam, those who came before the state and before 1966, those who came in between 1966 and 1971, and those who came into the state post 1971. So the first group was regularized, they were given citizenship. The second group was taken to be in the taken off of the from the electoral rolls and regularized after 10 years. And the third group, which came after 1971, they were to be detected and expelled in accordance with the law. So the 1971 cutoff date is very crucial, and this date was decided in the Assam Accord. Today, when the Supreme Court has upheld the validity, it means that the 1971 cutoff date has been restored, which is specified as per the Assam Accord, and following which anyone who has entered the country from Bangladesh to Assam after 1971, they are to be expelled and detected from the state of Assam back to Bangladesh. So this is a very crucial aspect of the Assam Accord, which has been upheld today, and following which it will be easier for the government to enact the detection as well as to proceed with someone who has entered Assam illegally from Bangladesh after 1971. Back to you.
All right. Now, also my guest, Vineet Jindal, in fact, is joining me on the broadcast. Thank you, Nibir, for giving us these details and giving us more perspective to what this landmark judgment means. Mr. Vineet Jindal, in fact, now the Assam Accord, which in fact is upheld by the 5-judge bench of the Supreme Court. This in fact is meaning that the illegal migration into the Section 6A to Assam has been given a resolution, and now as our correspondent Nibir Deka has also given perspective up to how this in fact means that people who have entered into Assam after 1955 will be expelled. What is your understanding and reaction to this upholding of this judgment by the Supreme Court?
The Supreme Court judgment has very much clear that who will get the benefit of Section 6A and who will be the eligible for the citizenship who has been come to India even 65, 71 and after 71. So it is very significant judgment. It is about to the persons who have been illegally entered into Assam from Bangladesh. The illegal immigrants after 71, they are now sent to back Bangladesh, and I think that is about to the prospect of stopping illegal immigrants from entering to India, and those who have been trying to get the benefits of Indian Citizenship Act, which has not been clarified, that how they will get the citizenship and how they will expel from the Indian territory. So now this has been clarified by the Honorable Supreme Court by this judgment, and it is very much convenient to the Assam government now to send those person who has been illegal immigrant after that.
All right, Mr. Jindal, I'll request you to kindly hold on to that opinion while we also get to the live briefing by the Supreme Court that has announced this landmark verdict.
And such power is not controlled and regulated by Part 2 of the Constitution. The other contention raised was based upon the dual citizenship. That also has not found favor with us, and we have held. Therefore, based on the aforementioned reasons, we are of the conceived opinion that the framework outlined by Section 6A is that an individual falling under Section 6A2 and 6A3 can only assert Indian citizenship. Such individuals are presumed to have relinquished their previous citizenship. If authorities have reasons to believe that the previous citizenship is still being exercised, they are empowered under Section 9 of the Citizenship Act and associated rules to take steps to revoke the Indian citizenship of the delinquent individuals. Consequently, it can be deduced that the Section 6A does not contradict Section 9 of the Citizenship Act, and we declare so. On the question of violation of oath of allegiance, again it did not find favor with us. We have said, moreover, the absence of such an oath does not absolve the immigrants from their obligation to respect the law and order of India Even when such oath is not taken before acquiring citizenship, every citizen has to compulsorily abide by the norms of the Constitution, statutory laws, and other rules and regulations. We need not further emphasize that once the immigrants have become Indian citizens by operation of Section 6A, they are regulated by the Constitution of India, the laws framed under, and the values enshrined within them. Hence, the explicit lack of an oath of allegiance before the conferral of citizenship by Section 6A does not absolve the immigrants covered under this provision from following the laws of our country just as any other citizen of India. On the question of Article 14, our conclusion is, as was discussed previously in paragraph 180 to 182 of this judgment, courts are generally tolerant of marginally under-inclusive legislations and recognize that similar cases may fall on both sides of the dividing line, provided that there is a broad discernible classification based on intelligible differentia. While analyzing validity under Article 14, the court has to be cognizant of the fact that any division done by a classification cannot be mathematically precise and accurate. As long as the broad purpose of the law is being fulfilled, a classification cannot be deemed unreasonable. We are thus of the considered opinion that even if there are states that could share similar characteristics with Assam, the comparison should be between two broad classes, Assam and the rest of India, rather than each individual constituent of these two classes. Since other states in general were not facing similar issues, the differentiation in classes was reasonable. On the point of manifest arbitrariness, we have divided in three parts. One is the argument was that cut-off date in Section 6A amounts to manifest arbitrariness. That we have not been able to accept, and we have held. Nevertheless, and as noted earlier, the determination of a cut-off date falls within the ambit of the policymakers, and the court would be reluctant to impinge into such fixation, save and except when the assigned date is vitiated with discriminatory and arbitrary considerations. Since the cut-off dates in Section 6A have been found not to offend the aforementioned principles, we are not inclined to interfere in the prescription of such cut-off dates. We may hasten to add here that Section 6A does not operate perpetually, and since it does not rescue those immigrants who entered the state of Assam on or after 25th March 1971 and has become redundant qua them, the cut-off date prescribed therein cannot be said to be tainted with the element of manifest arbitrariness. Similarly, the argument was that the procedure prescribed under 6A is also suffers with manifest arbitrariness. That also we have not agreed. From the above, it is clear that there are legible delineated conditions and a reasonable process envisaged under Section 6A and the Citizenship Rules 2009 for migrants who came before 1/1/1966, as well as for those who came on or after 1st January 1966 and before 25th March 1971. We have then held the above statutes for the reasons
Now,
assigned.
joining me on the broadcast on this landmark judgment, in fact, is Advocate Vineet Jindal to give us a glimpse of the landmark judgment by the Apex Court, which has upheld the Section 6A of the Citizenship Act today. And what this exactly means, this was Justice Surya Kant who has in fact given a statement also while announcing the verdict. What is the implication on Assam remains to be the big question. All right, Mr. Jindal, a quick response over what exactly this judgment is going to have the ramifications over. Please respond.
Look, this is very significant judgment. It is about to be the sovereignty and integrity of the country. So we have seen that there are several countries who have been involved with this illegal immigrants and facing a problem. So now Citizenship Act has provided something to the person who has been affected from the other country, and they can enter to the other country and will provide them shelter. But it is not for the person who has been come over to change the demographic position and to impact the sovereignty and integrity and law and order situation. So I think that is very significant judgment, and Honorable Supreme Court has now clarified that no such kind of illegal immigration can be taken place, and I think now the state of Assam can take appropriate action against the person who has been for enforcing them, enforcing in the Assam by the other countries to just to create a law and order situation, a threat to the country.
As Justice Surya Kant in fact has said that Section 6A specifies in fact greater implications, it can be deduced that the Section 6A does not contradict to the Section 9. What is your understanding of these comments that have been specifically underlined by Justice Surya Kant? First, the statement was read by the CGI, and now Justice Surya Kant has in fact given his verdict on the remaining judgment.
Look, I am not able to see what he is saying, but as far as my concern, that as the majority has been upheld, Section 6, and it is about Section 9 and Section 14. There are something which is different opinion has been given by the Justice Surya Kant and one of the other judge. So that would be a position, but in totality, this is a very significant judgment, and it is to safeguard the sovereignty and integrity and order situation in the country.
All right, Mr. Jindal, thank you for sharing your opinion. And as far as the landmark judgment by the Supreme Court, a 5 bench upholding the Section 6A of the Citizenship Act 1955 also is concerned.